ruling that has come out allowing web designers and other types of creative services to deny and discriminate against the LGBTQ community. So I have an opinion analysis by Amy Howe from scotusblog.com up, and I figured we would hear what it has to say. So let's give it a listen, and then I'm going to give you some of my thoughts as well.
Supreme Court rules website designer can decline to create same-sex wedding websites, Scotus blog. Opinion analysis. On June 30, 2023, the court ruled in the 3 final cases of the 2022-23 term on Friday. The court handed a major victory to business owners who oppose same-sex marriage for religious reasons on Friday. A 6-justice majority agreed that Colorado cannot enforce a state anti-discrimination law against a Christian website designer who does not want to create wedding websites for same-sex couples because doing so would violate her First Amendment right to free speech. Justice Neil Gorsuch wrote for the majority, in a decision joined by Chief Justice John Roberts and Justices Clarence Thomas, Samuel Alito, Brett Kavanaugh, and Amy Coney Barrett. He explained that Colorado cannot force an individual to speak in ways that align with its views but defy her conscience about a matter of major significance. And he indicated that the court's decision would provide similar protection to other business owners whose services involve speech, such as artists, speechwriters, and movie directors. But in her dissent, Justice Sonia Sotomayor, in an opinion joined by Justices Elena Kagan and Ketanji Brown Jackson, called the decision a sad day in the American constitutional law and in the lives of LGBTQ people.
Let's stop real quick and give justice and respect to where it's due. It is Justice Sonia Sotomayor and Justice Ketanji Brown Jackson, as well as, I believe, the sound butchered Samuel Alito. So I want to respect the positions that they hold, and I don't want their names butchered. So, but that's what you'd get with AI voices.
The court's decision came just over 5 years after its ruling in the case of another Colorado resident, Jack Phillips, a baker. But in her dissent, Justice Sonia Sotomayor, in an opinion joined by Justices Elena Kagan and Ketanji Brown Jackson, called the decision a sad day in the American constitutional law and in the lives of LGBTQ people. The court's decision came just over 5 years after its ruling in the case of another Colorado resident.
You know what, I just got to stop real quick and point out, this is one of the problems that we have with certain types of systemic racism, is when you have designers of technology who hold biases, they can then transfer that biases into the program of AI. And one of those ways that we know is because AI is not good with names of minorities, unfortunately, like Sonia Sotomayor or Ketanji Brown Jackson. And that's why we need more people of color in technology, and that's why affirmative action should never have been canceled. Let's go ahead and continue.
The court's decision came just over 5 years after its ruling in the case of another Colorado resident, Jack Phillips, a baker who refused to make a custom cake for a same-sex couple because he believed that doing so would violate his religious beliefs. By a vote of 7-2, the court gave Phillips a narrow victory, holding that the Colorado administrative agency that had ruled against him had treated him unfairly by being too hostile to his sincere religious beliefs. But the justices did not determine whether or to what extent a service provider's sincere religious beliefs might have to yield to the state's interest in protecting the rights of same-sex couples. Nor did they decide whether compelling Phillips to bake a cake for a same-sex couple would violate his right to freedom of speech. In the 5 years since the court's decision in Phillips' case, the composition of the court has changed significantly. Right, Kennedy, who wrote for the majority in 2018, retired less than a month later. He was succeeded by the more conservative Brett Kavanaugh. And 2 years after that, the court's senior liberal justice, Ruth Bader Ginsburg, died at the age of 87, allowing then-President Donald Trump to appoint another conservative jurist, Amy Coney Barrett, to replace her.
Which Mitch McConnell pushed through in 6 weeks after refusing to even give a hearing to Merrick Garland 11 months before, when the conservative, I can't think of what his name is, Scalia, had passed away. And President Obama nominated Merrick Garland. They refused to even give him a hearing months and months and months and months before, because he said it was an election year bullcrap. And then totally went against all those precedents that he had set when RBG passes and has 6 weeks before an election and shoves this ultra-conservative woman who has never even really had a career as a judge, was newly appointed by Trump to the bench, has no real experience in law. I mean, she was a lawyer supposedly, but it's really quite a shame how they have stacked the court to this ultra-conservative kangaroo court that is not legitimate because of how it was done. It was manipulated by the right wing, and the right wing owns them. The right wing evangelical Christians and billionaires own them, and it's clear by all of the ethics scandals coming out against the right wing conservative justices. Let's continue.
It was therefore a more conservative court that this term considered the case of Lori Smith, a devout Christian who owns a website and graphic design business in Littleton, Colorado. Smith wanted to expand her business to include wedding websites, but only for heterosexual couples, and she wanted to post a message on her own website to make that clear. But such a statement would run afoul of Colorado's public accommodations law,
Right.
which bars businesses that are open to the public from discriminating against LGBTQ people or announcing their intent to do so. Roughly half of U.S. states have similar laws. Smith went to federal court, seeking a ruling that enforcing the law against her would violate her First Amendment right to freedom of speech. On Friday, the justices agreed.
Absolutely.
The First Amendment, Gorsuch explained, protects an individual's right to speak his mind, even when others may regard that speech as deeply misguided or it may cause anguish.
But it's not speech.
And the First Amendment generally also protects an individual from being required by the government to voice a particular message.
See, at this point, though, it's not about her saying, I don't agree with this. It's about her denying a service, a business open to the public, which is discrimination, which is turning the LGBTQ community, us, into second-class citizens, which means that we can have LGBTQ web designers. That's separate but equal. Like, the court threw that out. Like, that is, but they ruled that it was unconstitutional. Like, this is just absolutely appalling. This is backwards and archaic, and they are, the right wing, the Republicans' desire is for us to have a theocracy, and their desire is to take us back socially to 1910, before women had the right to vote, before women had the right to a say, to a career, to her body, when colored and African American and other minorities had to be under law subservient to white males, specifically white Christian males, and where the LGBTQ community was so oppressed that they feared to even try to come out because they knew it would cost them, not only could cost them their lives and their families and their livelihoods, but could also literally have them killed. And that is what they're advocating. That is what they're pushing for. That is what they're doing, and they're making it possible with Mitch McConnell's right-wing stacked kangaroo court. This is absolutely not what the founding of America was about. This is not holding up to our philosophical ideas of every man, woman, and child is created equal and has unalienable fundamental rights from God. This is absolutely appalling. Let's continue.
In this case, Gorsuch observed, even the U.S. Court of Appeals for the 10th Circuit agreed that the websites that Smith wants to create are speech. But if Smith wants to speak, he stressed, she must choose between following her conscience, which means only creating wedding websites for opposite-sex couples, and violating Colorado law, or following the law and violating her religious beliefs. Under the Supreme Court's cases interpreting the First Amendment, Gorsuch concluded, that is enough, more than enough, to represent an impermissible abridgment of the First Amendment's right to speak freely. Gorsuch conceded that in some cases it may be difficult for courts to determine what qualifies as expressive activity protected by the First Amendment. But this is not one of those cases, he insisted, because Colorado and Smith both agree that Smith's wedding websites would be expressive activity. And Gorsuch warned that Colorado's position could lead to dangerous consequences. As Chief Judge Timothy Timkovich noted in his dissent from the 10th Circuit's decision, Gorsuch wrote, governments could force an unwilling Muslim movie director to make a film with a Zionist message, they could compel an atheist muralist to accept a commission celebrating evangelical zeal. And they could require a gay website designer to create websites for a group advocating against same-sex marriage, so long as these speakers would accept commissions from the public with different messages. Sotomayor's 38-page dissent argued that the Constitution contains no right to refuse service to a disfavored group. Colorado's public accommodations law, she contended, only bars business owners from discriminating against members of the public based on their sexual orientation. It does not regulate or compel speech at all. If a business owner like Smith offers goods or services to the public, Sotomayor suggested, she remains free under state law to decide what messages to include or not to include. But what Smith can't do, Sotomayor stressed, is offer wedding websites to the public yet refuse those same websites to gay and lesbian couples.
Right. Exactly.
Sotomayor lamented that Friday's decision declares that a particular kind of business, though open to the public, has a constitutional right to refuse to serve members of a protected class. More broadly, she continued, the immediate, symbolic effect of the decision is to mark gays and lesbians for second-class status.
Right. Exactly.
The Alliance Defending Freedom, which represented Smith, hailed Friday's decision. In a statement, lawyer Kristen Waggoner said that the court had rightly reaffirmed that the government can't force Americans to say things they don't believe. Disagreement, Waggoner continued, isn't discrimination, and the government can't mislabel speech as discrimination to censor it. Colorado Attorney General Phil Weiser criticized the ruling, saying that it threatens to destabilize our public marketplace and encourage all kinds of businesses, not just those serving weddings, to claim a First Amendment free speech right to refuse service to certain customers. Colorado officials, he said, will work hard to ensure that, within the confines of the court's opinion, we take action to hold accountable those who engage in unlawful discrimination. This article was originally published at Howe on the Court. Recommended citation, Amy Howe, Supreme Court rules website designer can decline to create same-sex wedding websites, Scottish blog.
So there we have that. That was an interesting tidbit. I am going to, as I said, do a video on the actual ruling in its entirety, so let's be looking for that. Thank you guys for being here, and I'm going to make several more videos on this because this is an extremely important topic, and this is opening the proverbial floodgates to serious discrimination and oppression nationwide against the LGBTQ community. And we know that the anti-LGBTQ movement is on the rise. There's, I think, 400 or 500 bills in the legislation. Some have been passed, some are still in committees. A few have been denied, but this is very, very dangerous times we're living in, and we have to continue to speak our truth. And I'm also thinking of making a video going over some of these bills and see what we can do there. So, thanks guys. Like I said, like, subscribe, ring the bell, all that good jazz. Thanks.